following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss Sri Lanka's Ayurveda Act. With controversial new amendments being brought into this sensitive piece of legislature, how drastically would these legal changes affect the existence and continuance of indigenous medicine and other cultural practices in our country? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key events in the legal sphere and breaking it down for the layman. Now, today's topic is something maybe not a lot of our audience has kept up with because it has been going on very constantly behind the scenes of the legal sphere. There's not much of noise around it, but it is certainly something that will be impacting all of us in a cultural heritage level as well as probably day-to-day impact if you have any experience with this field, and that is on indigenous medicine and the current Ayurveda Act and the new amendments that are coming towards it. And to speak about this specific, very controversial topic at the moment is someone that is very much well versed in this entire ordeal, of course, is Mr. Krisantha Nissanka, attorney at law. Thank you very much, sir, for taking the time to speak to us. So, Mr. Krisantha Nissanka is actually the convener of Lawyers for Buddhist Rights, and he is a very staunch supporter and a propagator of the indigenous medicines and the protection of this culture and heritage that's part of Sri Lanka. So we have a lot to break down in this entire discussion. First, we'll be talking about the history of indigenous medicine and how it came to be in a legal context and where we are at currently. Next, we'll be talking about the current obstacles that are faced by indigenous medicine in regards to the current amendments and the acts that are in place, the current context. And finally, we'll talk about reforms and what could happen in the future in relation to indigenous medicine. All right, well, without any further ado, sir, let's get right into the discussion. Thank you once again, sir, for speaking to us today and to enlighten our viewers on this topic, this very important, very timely topic. Sir, now, I'm sure a lot of us would not have full understanding of Ayurveda in a sense, and indigenous medicine, but I'm sure a lot of us would like to know, in a legal context, how has it come into play historically? How has indigenous medicine come into play in a legal context? What are the acts that are present and how is it functioning at the moment?
Well, historically, the indigenous medicine was based on the Buddhist practice. We should recall that Ceylon or Sinhala had its hospitals long time before any other country would have it. So we should be very proud of our history because we have initiated hospitals for the well-being of the people. So that shows the history that has so much to do with Buddhist culture and Buddhist law or Buddhist Vinaya, where in the Buddhist Vinaya there is a special chapter called Besajja Kandaka. That is part of the Vinaya. Buddha has preached stating that the Sasana will prevail only if this Vinaya prevails. In another sense, if not for these Buddhist medicinal practices, Buddha Sasana will not exist. So that is the philosophical background of this particular subject. And Buddha has always given medication to monks during his 45 years tenure. And that has been brought up to now through monks, through laymen, upasakas, and who have nourished it by preserving it through Vattoru Vedakama. They have written these things on Ola leaves and taken down the history, and at the same time they have done so much of research during these 2500 years. And that is, now you will see this, when you talk of history, I have brought this particular book on, that is called Talpate Piliyam. This is a collection, you get 26 volumes on this particular book, which the Ayurveda department has printed, and there are thousands and thousands of Vattoru Vedakam, or medications done by Buddhist monks and brought down the tradition, and they have printed all those Ola leaves into this set of volumes. So this is now every person can, any person can have access to this Talpate Piliyam. It's in the internet also, I came to know. And this is a people's, what you call, barefoot, I call it barefoot doctors. Robert Knox once said, every Sinhalese man is a Veda Mahatya. That means everyone knew his medication, right? So this was based on Buddhist traditions.
I see. So based on Buddhist traditions, but not just including Buddhism, it has spread currently. In the current context, we have seen that there is, I mean, for a lot of us, it's an intrinsic part of our lives. We've had an encounter with indigenous medicine at some point. Sir, if you could explain to us now the current act that is in place, could you please break down to us what exactly entails this act and what salient features are present in it?
Now, when the British ruled us, they accepted the fact that we had an indigenous medicinal system, because they didn't have to spend much on medicine because we already had it. So they enacted in the name of Indigenous Medicines Ordinance. But later on, this was transformed into Ayurvedic. Then came the Ayurvedic Act. And now they are going to turn it into something else. Ayurvedic into Ayurveda. Now this is the issue. So, what the indigenous system we had was basically based on Buddhist medication, and though they didn't call it Buddhist because it was highly practiced by all, very well practiced by all. So they didn't want to give this name Buddhist, but now the time has come to find out the authority on this, and that is why I am focusing on this Buddhist Baisajya. So now, why do they want to change from indigenous medicine to Ayurveda, Ayurvedic into Ayurveda? That is the issue. The reason is this. Most of the indigenous practitioners were called as Vedaralas. And when the Western allopathy came into practice, they wanted to be in par with that system. So they wanted to have a system which should be compatible with the Western method. So that is how this Ayurvedic thing came into being. So in India, this Ayurveda thing was there, and I hope it had some influence on our system, and they brought in a prototype of that Indian thing. But still, until now, we didn't have Ayurveda in our act. Though it was called Ayurveda Act, in the definition there was nothing called Ayurveda. It was, the definition on Ayurveda was, Ayurveda means and includes Siddha, Unani and Desiya Chikitsa and some other things. Now with this new amendment only they are bringing in Ayurveda. So that is the history.
I see. So now you mentioned that Ayurveda, the indigenous medicine practices, was not what was wholly comprised of the previous act or the current act that we're in. Could you explain a little bit further about that, sir? How bringing in this new amendment is going to include the medicine aspect as well?
Which medicine?
The indigenous medicine aspect.
Indigenous aspect, yes. Now, the designers of this act, the Ayurveda department, very well knew from the very beginning that there was this Buddha Baisajya. But they were very careful not to include that in the system, in the definition earlier. Instead of going for Buddha Baisajya, they called it Deshiya Chikitsa, which is not the proper name. And the traditional things, traditional medicine was kept out. Now the traditional, among the traditional definitions, they have included Ayurveda into it. Why? Because the Ayurveda has its, when you take Ayurveda alone, it connotes a religious concept. It has so much to do with religion. But in the Constitution, it's prohibited because Article 9 is very clear. Article 9 states that Buddhism should be given the foremost place, and at the same time, the state should protect and foster Buddha Sasana. So this Buddhist medicinal practice is part of the Buddha Sasana, intrinsic part of the Buddha Sasana, because it comes under, now Buddha Sasana definition, there are three things. First thing is that it is called the Pariyatti Sasana, that is the doctrine. Then comes the Patipatti Sasana, how it's been practiced. And then comes Pativeda Sasana, the realization of the truth or the nirvana. Now this Baisajya Kandaka is part and parcel of the practice, the Patipatti Sasana. So no other religious or medicinal methodology could be inserted into this without the approval from the Sangha. Right? And no one can force Buddhist medication to register under Ayurvedic system because it's another religion. It's like some other religion asking to register other Buddhism under their religion. So this is our main argument against this inclusion or intrusion, I call it, right? Kind of an intrusion into the system by way of government authority. It's the state who is proposing this. State can't do this because there is case law to that effect where it states that no other religion could surpass Buddha Sasana. And that is why propagation is not allowed in this country. Other religious propagation is not allowed in this country. Anyone can manifest religion.
So the current amendment is almost a propagation of
It amounts to propagation because now in most of the cases, there are three cases, one called the very famous Mensinjan Sisters case and the New Harvest Wine case, and all these are determinations, and another Sahanaya Doratuwa. In all these three cases, the Supreme Court was of the view that anything against Buddha Sasana will not be allowed. So, if Ayurveda amounts to it, if Ayurveda religion is going to go against Buddha Sasana, definitely that is not allowed. That is why it's illegal to have this Ayurveda religion coming into the system through government legislation is very bad in law.
I see. So, sir, a question of curiosity here.
Yeah.
Now, the new amendment that is being brought forward, it is essentially a regulation of the medical practices, right?
Yes.
Of the indigenous medical
Yes.
practices. So, if it is a regulation of such, could you explain to our viewers how that could be drastic to the currently present, the cultural aspect as well as the intrinsic aspects, the core values of indigenous medicine in the country?
Well, what I saw in this amendment, it was mainly focusing something else. It was focusing on massage clinics, spas, because their main aim is to promote massage clinics. Now, the present situation, you should have an Ayurvedic doctor who should be in charge of the massage clinic, which they are not in a position to provide with. So now they want to train massage therapists. And you know, at present you get spas. You don't get doctors there, I don't think. So now when they do this, what will happen to the culture of this country? Even now, illegally there are so many spas around the place. By bringing in this, it will be another
Floodgate scenario.
Floodgate scenario, which would be similar to Thailand and other countries where you have spas around the place, and prostitution will flourish very soon if you bring this in.
So in a way, it is almost derogatory to the long-standing practice that has existed in the country in relation to indigenous medicine as well.
Not only indigenous medicine, I mean the culture of the country. And it's against the Article 9, because Buddha Shasana, you don't promote spas and prostitution. Prostitution is not allowed in the Buddhist culture.
There is a lot for us to discuss as well. So when it comes to the current context and what efforts have been made to at least adjust the amendment or maybe make some room for authentic fostering of indigenous medicine. But before we speak about any of these topics, let's go in for a very short commercial break. You're watching Law, Land and Liberty. Stay with us. Welcome back to Law, Land and Liberty. We were in conversation with Attorney at Law, Krisantha Nissanka. So we were talking about the controversial aspects of the new amendment that is coming into place and what it is doing to indigenous medicine in Sri Lanka. So if you could, when we left off, I feel like there was a little bit more to discuss as well regarding why there's such an issue with the amendment that's coming into place. Could you explain to us about the biggest obstacle or the biggest concern we see when it comes to this act?
Now you will see that we have signed the Alma Ata Declaration, International Declaration on Primary Health Care. Now the Constitution says when you sign such agreements with the international community or the conventions, you have to abide by them. Alma Ata is clearly emphasizing the fact that now the courts of this country has accepted that there is a right to life. Right to life is essentially right to health. Without health there is no life. So this International Conference on Primary Health Care, which was held in 1978, and the Sri Lankan government is part and parcel to that agreement we have signed. Now, in that agreement, there are certain very important aspects on primary health care. One is the people have a right and duty to participate individually and collectively in the planning and implementation of their health care. Now, though this says so, it was part and parcel of our day-to-day life. people actually participated in this process, especially in the temples. People gathered, Gilana Pacha, that is how it goes. And they offered these medicines to the Sangha. They did these meritorious acts collectively. And not only that, you get so many Veda Mahatyas around the place. In any village, you get 100 to 150 Veda Mahatyas around the place. Visa Veda, Gas Veda, then you call them Kadum Bidum Veda. All types of Veda Mahatma. And sometimes Khattadirala, who attends to your mental well-being through rituals, traditional methods of music and all these things, drum beating and all this. So that is a main aspect which we have signed on this particular Alma-Ata Declaration. Now, Article 157 of the Constitution very clearly states, when such treaty or agreement shall have the force of law in Sri Lanka, now these agreements have force of law in the Sri Lankan context, and no written law shall be enacted or made, and no executive or administrative action shall be taken in contravention of the provisions of such treaty or agreement. I don't know how they have created this amendment when there is a clause in the Constitution which clearly states we have signed all the UN declarations on health, and health is priority. In Buddhism also, under Article 9 also, other than 157, Buddhism speaks of Arogya Paramalabha. That is the greatest wealth of the people. So this has been accepted norm, right? This norm has been violated by introducing certain things. Now you will see in the act, in the amendment, the money is allocated for the well-being of the people have been cut off, right? So that is against the law, against Article 157, against the policy in Article 9. So is this the way we are going to be in par with the international community? They are watching us very carefully. And what we do and the way we act and what is in the books doesn't seem to go together. So it's high time that we should rally round to press the government not to bring this type of amendments without participation of the people. This was not made after a discussion with the people. Some officers in the department has decided to come out with this suggestion. And now we have to fight against it. These people who have created this has no idea of any of these international regulations.
It's not born of the public opinion.
It's not born of the... Where it says very clearly, the people have a right and duty to participate individually and collectively in the planning and implementation of the healthcare. Where has they done it? Have they had a meeting? Have they gone for a poll? Have they asked opinions of the masses to come out with their suggestions? Nothing. And suddenly they bring for the purpose of cultivation of, what do you call this, Kansa. That is their aim. They want to cultivate Kansa in bulk. And that is what the Ayurveda minister said very recently. The purpose is that, and to have spas. And this is not health. Right? So what I am saying is, people should read these things. The Alma-Ata Convention on Declaration on Primary Health Care. Now you will see, Buddhist medication is not to cure. It is to prevent illnesses.
It's a lifestyle.
It's a lifestyle, right? It teaches how to develop your mental ability to refrain from getting sick. Now, I have gone through some of the latest developments in psychiatric treatments where it says psychoneuroimmunology. That is, immunology is based on your psychological patterns. So this is what Buddhism has touched upon. So, having this wealth in hand, why should we go for Ayurveda, which is something foreign, which is based on a religion? Now, when Buddhists die, they go for what you call contemplation of death, marnanusmriti. We don't go after gods. We don't worship gods and ask them to rescue us, right? But in Ayurveda, it is not so. They do all sorts of yaga homa and they praise their lords, their Brahma, and these two different things.
So essentially, what we sought to protect is not what is actually being addressed in.
That is exactly what you said is correct.
So there is a big disconnect. There's a dissonance when it comes to what you mentioned, sir. Now the indigenous herbs, indigenous practices. Is there no form of current regulation that is in place that is going to be affected by this?
Now they say that there is a code under the earlier act. Actually, they have not prepared a code even for that. I mean, we could have thought positively if they had done certain things on that act. No. This is the first time they have understood that the Ayurveda is not there. The name was not there, but Ayurveda practice was not there. What they have called as Ayurveda was not exactly Ayurveda. So,
sir, a question of curiosity once again. Now, sir, we discussed this a little bit, touched on it a little bit earlier as well. So when it comes to bringing in an amendment, this is an amendment that's going to come in to the current act and cause a lot of disconnect and dissonance. So you mentioned earlier before the screens that it cannot essentially be an amendment if there is no original source material. So could you explain to our viewers exactly why this is so and how this amendment is not exactly an amendment at all?
The reason is, now the language plays a, now law is nothing but language. The will of the people presented by way of a language, sentences, and that is called constitution or law. So, if the people have not understood what is in the law, then how can there be a law? People, we have a different system of governance in this country. This is not a Westminster system. We had this. Now the present system is our representatives make law, and if it is against our will, we have another method of making laws by ourselves. That is in a referendum. People can go request the president to make laws through a referendum, and if the parliament does something wrong, people can enact laws beyond the parliament by voting in a referendum. So it's high time for us to think of these terms, because what you call this law-making process, you have to request people to come into it. And the language issue is this. Now, take for instance the Constitution, Article 9. In the English version, there are two sentences. Sorry. In the Sinhalese article, there are two sentences. In the English one, there is only one sentence. Then what happens? that means the English sentence cannot be taken as law, because the Sinhala text prevails. The law says the Sinhala text prevails. Now, this principle on the Sinhala text prevails, when you apply this to this scenario, this problem, from where have we got this amendment? The Indigenous Medicines Act and the earlier Ayurveda Act was written in English. And suddenly this amendment is done in Sinhala. How can you amend the English Act in a Sinhalese one, through a Sinhalese one? That is illegal. Now, regarding that two-sentence thing, there is a case, Pinto versus Trailberg. In that case, the court has identified that when a thing is being said in two sentences, you can't turn it into one and say that is the law. So here there is no law at all, because there was no Sinhala document prevailing, because based on that only you have to make the translation, the amendment. And how can there be an amendment when the original thing is not there?
There is always, especially when it comes to the language, I feel like our audience should really understand the gravity of the differences of language and how the Sinhala text prevails over the English in any scenario, and how there is no basic a base on which to amend with this current amendment. Sir, before we go in for a break, I want to ask you very quickly, sir. You mentioned earlier on in the discussion that the people were not come into consideration regarding the new amendment. Could you explain how that affects the legitimacy, how that affects the gravity, the weight of this amendment that's being introduced?
Yeah, this was done suddenly. This was, I don't think still, now even the Tamil translation of the document, now we didn't discuss about the people, Tamil speaking people. Now, there was no Tamil translation as well to the Ayurveda Act. Now, the one which has been introduced, that is the amendment, gives no meaning at all. Most of the words are not the same in the Sinhalese one. So, what about the Tamil speaking people? They also should read this in Tamil, no? Right? And certain things in the Tamil text, English Sinhala text, and the English text doesn't tally at all. So this is a subject which has to be addressed basically based on language, because neither the Ayurveda is in English. All Ayurveda documents are either in Sanskrit. The Baisajja Kandaka is not in English. It's in Pali language. Right? Then the local Vattoru, what I focused on, that is Palpatepilam, it's in Sinhala. Verse, in a Sinhala verse, not ordinary sentences. Yes. Right? Now, how can we discuss these things in English? Now, I should tell you, there is an article that is called 105 subsection 4 in the Constitution, which is very relevant to this matter. That is, in 105 subsection 4, it states like this. I think this is very important for the public to know, because this type of jurisprudence, this is a separate jurisprudence, because Buddhism is discussed, then Ayurveda principles, religious Vedic religion is discussed, and the Sinhala language issues are being discussed. So, what 105 subsection 4 says is that Parliament may, by law, provide for the creation and establishment of courts, tribunals or institutions for the adjudication and settlement of matters relating to the discipline of bhikkhus. That is Vinaya. The the what you call this, Besajja Kandaka is part and parcel of the Bhikshu Vinaya. So, the English one says very clearly, the Parliament may by law provide for the creation and establishment of courts, tribunals or institutions for the adjudication and settlement of matters relating to the discipline of bhikkhus, or any dispute between bhikkhus or any other dispute relating to the performance of services, which is the medicinal part of it, because it's the performance of duties to the parcel of it, and or in relation to temples. Such law may, notwithstanding anything to the contrary in this chapter or chapter 16, make provision for the appointment. It goes on and it says there could be a separate court for this purpose. Now, in every temple there is a courthouse that is called Pohayagaya. In that you discuss these things. So the Parliament has to make this institution to discuss these matters, because this is a different jurisprudence which the Parliament has not done up to now. After 45 years, still they have not done it. Instead, they go on doing things which are not, not within their purview, right? Instead, what they should do is they should create this institution, that is the Sanghadhikarana.
Exactly, there should be a separate...
Separate, because in that only they who are versed in that, well versed in that particular subject could...
So that there is accurate and responsible regulation and protection, especially when it comes to this cultural aspect as well,
yes,
and the authenticity of indigenous medicine.
Yes.
Definitely. Well, unfortunately we've come up to time in this segment. We have a lot more to continue as well, sir, regarding the future of indigenous medicine in Sri Lanka and how these reforms might affect and what we can do to help combat these changes. Before that, let's go in for a very short commercial break. You're watching Law, Land and Liberty. Stay with us. Very good evening and thank you for joining us once again after the break on Law, Land and Liberty. We were in discussion with Attorney at Law Krisantha Nissanka. We are in our final segment, sir, and we spoke a lot about how drastic this amendment is and what issues are actually present when it comes to not just the legislative aspects but also the hereditary and cultural aspects and how drastically it affects Sri Lankan culture in a sense. So, sir, the final segment we actually had a little bit more to discuss regarding how drastically the amendment has made changes, has attempted to make changes that are not exactly welcome or supportive in any sense towards indigenous medicine. So, sir, for the final segment, could you please explain to us now the reforms aspect? In your opinion, sir, how should we be combating this kind of unnecessary change?
Well, we should inform the people first of all, and that is what's happening. But I should bring to the notice of the people one important aspect of this. That is, by this legislation, now we saw this QR code coming into being. That now the government knows exactly how many liters we are using, so they can tax us on it. What I saw through all this legislation was that they are going to tax on each and every plant we do in our gardens. Now, one aspect is this: they are going to regulate the entire garden of every man, every household. That is, now I told you this. Now, even now in the villages, people put a small leaf of kangsa or kangsa leaf into the curry. In the villages, they live for about 115 years. That is the average. Now, the reason is this medicinal plant. Now it was regulated. What happened? No cancer plants thereafter. Right? People lost the opportunity of having this wonderful medicinal plant in their meals after making it illegal. They lost it. Now the same thing is going to happen not only to cancer, but to Karapincha, Rampa, everything. Very soon, if this act goes on like this, behind this are multinational pharmaceutical companies, because they know a large part of the budget is on health. Now that has been covered by this indigenous medical practitioners. Most of the people don't run to the hospital all the time. Now when this COVID thing came, people didn't run to the hospitals, they avoided the hospitals and they went into the indigenous people. Now the international pharmaceutical mafia knows it very well, and they want to grab the whole thing into their hands through legislation. Through legislation, they are going to. What is the purpose of regulating the day-to-day behavior of an average man? This is illegal. It's a violation of a fundamental right of a man, right? To have control over everything. Are we in a police state? Huh? I don't know what they are up to. I think because of this, people should come to understand that there is something behind. That is, very soon, every man will be taxed on every plant because it's money. Now the whole world is asking for medicinal plants. It's true. Now the minister also mentioned about it. He didn't come out with the real truth. They are going to have control over the whole thing and tax on us. They are telling that they are going to earn money. True. But how? At whose expense? And at whose violation of rights are they going to earn that money? So we are a free nation. We have the right to think freely according to Buddhism. We are not, in Kalama Sutra, Buddha says, preaches that you have the freedom of thought, right? Even Buddha can be questioned, and that type of freedom we have. So if Article 9 gives us that freedom, can a parliament or a minister or a regulatory body? No, they can't stop us.
That is the final message. I mean, it is extremely vital that we understand that it is not just a regulation of indigenous medicine, but also a regulation of our right to choose and of health that has already been in danger or endangered over the fast developing westernization of culture in our country. So, sir, unfortunately, we have come to time and we have expended all the time we have to discuss about this topic for today. But I'm sure that the viewers today would walk away with a very important message about what needs protecting and what we should do as citizens of Sri Lanka in order to prevent any sort of desecration of our culture and our heritage. Thank you very much for your time, sir.
Instead of saying thank you, I would say, in the traditional way, Pin Sidu Veva, for this meritorious act, for allowing people to understand the truth. That is, Pachattam Veditabbu Vinyuhiti. One should understand for himself. Thank you.
All right. Well, we leave you tonight with the words of B.R. Ambedkar, who is a former Minister of Law and Justice of India. Law and order are the medicines of the body politic. And when the body politic gets sick, Medicine must be administered. That is all from us here at Law, Land and Liberty. If you had missed any of today's programs, you can always catch us on our YouTube channel, youtube.com/otherthereinenglish. Thank you very much for watching. Have a great night.